Yes, good afternoon, everyone. Those participating in this webinar right now and those who will be watching later, welcome to the NBA-SBL Business Law Weekly, Season 3, Episode 3, organized by the Construction Projects and Infrastructure Committee of the NBA-SBL, currently chaired by the learned SAN Andrew Odu. The NBA-SBL, that's the Nigerian Bar Association section of business law, for those of us who are not aware, is one of the specialist sections of the NBA, set up primarily to engender the professional development of Nigerian commercial lawyers, thus raising the level of business law practice in Nigeria. Now, this section has at its apex a council, which is currently chaired by Dr. Adeoye Adefulu, with 12 other members and 24 sector-focused committee, one of which is the Construction Projects and Infrastructure Committee. And the section has been established to cover existing and new areas of commercial law with a view to enhancing commercial law practice among Nigerian lawyers and law firms. My name is Aderemi Ogunbanjo, partner at Tope Adebayo LP and the second vice chair of the Construction Projects and Infrastructure Committee of the NBA-SBL, and I'll be your host on this session of the Business Law Weekly. Today, we'll be looking at the topic, dispute resolution clause in construction contracts, selecting the appropriate resolution method for your project. And with me this afternoon to do justice to this topic is our highly esteemed guest, Barrister Ewuwuni Onogen Theophilus. Ewuni is a lawyer and an ADR practitioner with over 14 years of experience. She holds a Bachelor of Laws degree from Obafemi Awolowo University, Ile-Ife, Nigeria. She also holds a Master of Laws degree in construction law from the University of Strathclyde, Glasgow. She's an arbitrator, MCIR, a certified negotiator, program on negotiation, Harvard Law School, an accredited mediator, ICMC Nigeria, an adjudicator with the Ontario Dispute Adjudication for Construction Contracts, ODACC, the adjudicator nominating authority for Ontario in Canada, and a notary public. Ewuni is listed as member in the panel of neutrals of select multi-door courthouses across Nigeria, and is an executive member of the Construction Projects and Infrastructure Committee of the NBA-SBL. She's a member of the Institute of Construction Industry Arbitrators Nigeria and the Scottish Arbitration Centre, Edinburgh. Ewuni is a leading legal authority on the Nigerian construction sector and has authored the first and only Nigerian book on construction law titled Construction Law in Nigeria. She regularly delivers papers and presentations at domestic and international seminars, trainings, and workshops, and has moderated sessions at conferences on ADR and construction law. So I'm sure you agree with me, ladies and gentlemen, when I say that Ewuni would definitely do justice to this topic. You're very much welcome, Ewuni.
Thank you so much, Aderemi, for the kind words and the lovely introduction. Hello, everyone. I'm happy to be here. Thank you so much for inviting me. CPIC.
We're so glad to have you, Ewuni. Now, for construction projects, issues such as the parties involved, and usually sometimes we have parties like governments, multilateral financial institutions, and multinationals, and the specific economic and political context and the peculiar features of major construction projects, usually make disputes inevitable. And it's been found that cost overruns in large engineering, construction, and infrastructure projects can range from between 30% to 700%. And poorly defined contract terms is one of the causes of such overruns. So disputes are bound to occur, definitely. And when they do occur, Ewuni, I think you agree with me that having a clearly defined and effective dispute resolution strategy within the construction contract can save parties significant time and expense. So could you just tell us a bit about dispute resolution in construction contracts generally?
Okay, so like you rightly said, Aderemi, disputes are bound to occur, and the construction project, you have so many parties in it, different professionals. You have the engineers, the architect who who come up with the drawings. You have the builder, the contractor who will build it. You have the subcontractors, the suppliers. All these people now, they would have their own agreements, their own contracts regulating their relationship with each other. With the architect, you would have the architect will have a consultancy agreement with the employer, that's the owner of the project. The owner will have a construction contract with the contractor that will build it. The contractor will have his own agreement with the subcontractor, that is like the plumber or the electrical engineer, So all those people will have all these these different contracts come into play in this project. And any disputes in one of these contract, in one of these relationships will reverberate, will affect the other contracts. The progress of the works is affected. So that's like it gives you an overview of how complex the disputes can be and can come up.
Absolutely.
And if it's like a PPP project now, where you have financiers now, lenders and all that come in, they will also have their own agreements to their lending agreements to finance the project. So all those things come in to make it a very complex situation. So for that reason, there are so many different, there are so many different types of methods that are being used in the industry to resolve this disputes when they come in. Like you rightly said, the cost overruns is a type of a dispute can come in when the cost is too high. They've gone up above budgets. If the owner is saying you are not building according to, I did not ask for this, the specifications, the materials supply, the quality of workmanship are some of the disputes that can come in to play in a construction project. So
absolutely. Absolutely. Thank you so much, Ewuni. So what are the different types of dispute resolution methods that you find commonly used in construction contracts?
Okay, so basically there are two. I'm just going to say two: litigation and ADR. ADR is like the umbrella word for every other thing that is not litigation. So we have litigation. We know you go to court using the court system to settle disputes. Then we have negotiation. Is usually the very first point of call, the most often used one, because in a construction project, you want to keep the relationship between the parties alive. So you have negotiation is an informal process of discussion between parties, meeting to just talk out their issues. It could be it could be written via emails, or it could be oral face-to-face talk. And then it could also
sorry, Ewuni, just a second. Apologies. There's a background noise there. Can we mute our mics? If anyone has their mics on, can we please mute our mics? Thank you very much. Apologies, Ewuni. Please
no
proceed.
problem. So I hope I'm clear. My voice is,
yes.
My audio is okay. Okay.
Yes, it is. Thank you.
Okay, so we have negotiation between the parties that can happen at project level. That's the site reps, the site officials on site to talk, and if they can't settle the matter, they'll escalate it to their executives. So that's negotiation for you. Usually negotiation is non-binding as such. The negotiated agreement is not binding, and if a party decides not to comply, you have to go to court to enforce the agreement, because what will come up after the negotiation is to come up with the terms of settlement, kind of, that you can enforce as contract. You still have to go to court. Then you have mediation, which is just a facilitated negotiation. I would say there's a neutral third party that assists the parties to come to an agreement, to a solution, and he has no power to impose a decision on the parties. He just facilitates, he assists them to come to an agreement that is favorable to both of them. Then we now have adjudication. Adjudication involves is an interim method. People might be familiar with adjudication, and they relate it to litigation as being adjudication. But in the construction sector, there's a special ADR procedure called adjudication. It's an interim dispute resolution method. It's very quick. The adjudicator has to issue his decision within 28 days of his appointment. So it could be statutory or ad hoc. In Ontario, Canada is statutory. There's a statute that provides for it. In the UK is statutory, but in Nigeria, adjudication is contractual. There's no law giving the rights to adjudication. So adjudication is also confidential. So it's but if the decision, the determination of the adjudicator is binding in the interim and is like pay before complain, obey before complain, you have to comply with the adjudicator's decision. If you're not happy with it, you then move forward to arbitration or litigation or further negotiation, amicable settlement or something. That is only when that is how you can set aside an adjudicator's determination. So it's really useful for allowing money to flow in the project. So it's used mostly for payment disputes. For instance, the contractor has done work and he hasn't been paid. There's delay in payment. He goes to adjudication, and the adjudicator just looks at the documents and the invoice and says, and the terms of the contract, and says, owner, you have to pay, and then he pays up. So and then if the owner is saying, no, I don't want to, I don't think I should pay this guy because his workmanship is wrong. I said he should build 3 windows. He gave me 5 windows. If that's his problem, okay, sharp pay the money, and then you can go higher to court or arbitration, depending on the terms of the contract between the parties. Then you have a mini trial. This one is just the lawyers from both sides, they'll come and present their cases before a panel of 3 people made up of the executive from one party and the executive from the other party, and then a neutral third party that just stays there to facilitate and act as a mediator. So when both executives now, it's like big man talk to big man kind of thing. They hear what their lawyers have to say, and they can be like, because these are business people, like, is there really need for us to fight? Like they can see the strengths and weaknesses of their cases. So after the presentation by the lawyers have been made, the executive, the big ogas can now negotiate, like, okay, I can agree to accept this, let me say the 5 windows, but you're going to do something else for me or something, they can now negotiate based on that. So that's mini trial. So it's a non-binding thing. It's like negotiation, but it's negotiation not with the lawyers involved. Like, what is going on, your structure and all that. Yes, exactly. So yes, but party can decide that whatever happens after that, they might say, okay, we'll be bound with the decision. Then expert determination, let me hurry so that, because we have so many things to talk about. Expert determination is like adjudication kind of, expert determination is when technical issues in the project are referred to an expert. For instance, issues of constructability of the design. You might have an architect that designed one house that one side is like somehow it's like this, and then issues on whether that design can be constructed and it will not fall might come up. So they will now have to maybe refer that issue. That's a technical issue, refer it to a structural engineer, so issues like that. So this one, the man uses the experts there, uses his expertise to make a determination. His determination is not binding unless parties agree to make it binding, but his determination it's useful for subsequent negotiation or any other dispute resolution procedure that the parties have agreed to. They can use it and say, this is what the expert determined in this situation, that this design is not buildable, so that's expert determination. So then we have arbitration, which we are all familiar with, which is like the junior brother of litigation, where party gets this one, they get to choose their arbitrators, determine the rules that will govern their situation. And then dispute boards, that skipped my mind. Dispute boards, these are a panel of experts too, appointed. Sometimes they are appointed from the beginning. They are standing committees appointed from the outset of the of the project, sometimes they could be appointed as issues, as disputes arise. They come to, if they are from the outset, they attend site meetings, they are familiar with the project. So if anything comes up, they advise the parties, they can offer an advisory role. And then if the advice is not taken, if that issue becomes a dispute, they can now adjudicate on it. So that you find that being used in the 2017 FIDIC standard FIDIC contracts. So yes, that's the list of the most often used dispute resolution methods in construction industry.
Thank you very much, Ebony, for that in-depth analysis. And one of the interesting things that we've also alluded to with regards to construction contracts is the fact that sometimes practical issues, including claims, can be dealt with during the currency of the works, because you don't want a situation where one particular aspect delays the whole project and possibly, the commissioning dates, the completion dates and all that, and cost overruns keeps, building and building. So typically you would have at least one or most times a combination of some of the dispute resolution methods that you just highlighted in a particular contract, right?
Yeah. Yes, that is
so how do you then determine which dispute resolution mechanism or method or the combination of some of those that you've said that is suitable for your own particular project or construction contract?
Fantastic. So you have to know look at the procurement method, the project delivery method that was used. It's one of the things you should look at. For instance, traditional method, that is when an employer gets an architect to design a building for him, and then he gets a contractor to build it for him. That's traditional method. Then you can now have the design build, where the employer gets the contractor, you design and you build. Then you have the PPP, the public private partnership, all those different things. It also affects the types of disputes that could arise. So the nature of the procurement method determines what type of dispute resolution method, because the dispute that arise in a PPP will be different from the nature of disputes that could arise in a traditional method. It's possible the same thing, delay in payment can come up, but financing disputes, it's still there, but it will not be as much as it is in a PPP when compared with traditional procurement. So you look at that one to then the nature of dispute dispute. Before you start drafting, try to think of the sort of dispute that could arise in this project. Projects are unique, are specific. There is not no project is alike. The site is different. You might be building in raining season, and the other project was built in Harmattan. So you look at the project, the type of project you have, the size, the complexity of the project. If you have a payment dispute, for instance, contractor has submitted an interim payment certificate and it has not been paid out, and he needs the money for cash flow in the project. So you would have to use adjudication 28 days, even expert determination 28 days. The money is out for the man to have his money, So adjudication is advisable for payment disputes. If it has to be, like I said, technical issues, then you will have to put expert determination. And then if it's for schedule, like delay in completion of the works, then you use negotiation, mediation, because the guy, you give him more time, negotiate extension of time for him to complete the work. And you can say, okay, I'll give you more time, but you would, the contractor might say he was delayed because he was not given access to site on time, blah, blah, blah. They can negotiate something, that, okay, because I did not give you access to site for you to start on time, okay, I will give you more time to complete and you will not pay delay damages that one is even basic because it was the employer's fault that he did not start on time. So the quality of works, so that one has to do with technicalities, whether it's up to SPA, if it's the specification, the material supplied to site, is it up to the specification, is it in accordance with the specifications? For that type of thing, you use expert determination and interpretation of contractual terms. Was there really a breach? Does it really have the right to this particular thing? That when you use DRB, arbitration is necessary in that type of situation. So you look at that, you look at also the size, the sophistication of your client, you look at the financial capability of your client. You know, I read some contracts, and this is a homeowner building house. You're putting arbitration with three arbitrators, you know.
Absolutely.
The money alone, how much is look at the value of the contract, you know, how much is the money the man is paying his contractor before you now come and start, he has this, now you now pay 3 arbitrators, you know. Some of these things, you have to look at all that and take into consideration the parties, their financial capabilities, their sophistications too. And then you can, if it's a complex, a large project that value is high, arbitration is important because, you know, what is at stake is really, really high. So you use arbitration where you have a structured process. So another thing you can look at is, I had said cost, the cost of the proceedings. You should look at that. And then I had mentioned earlier on that there are different contracts that come into play: the subcontract, the main contract, the supply agreement, the consultancy agreement. Look at all these things. Look at their own dispute resolution methods. When you're appointed to, when you're briefed, you know, look at the dispute resolution methods in all these places, and then you pick the one that is in line. It's not as if these people, they are using mediation, you went to put arbitration there, you know, meanwhile they have in your own agreement. Meanwhile, these people have settled their matter, which your own too is, whatever dispute was in the other thing is affecting your own contractual agreement. So it has to be holistic. You ask for the other agreements, any other agreement that have been entered, any document, go through it and try to tailor your dispute resolution clause in line with the other one. So in case there's a possibility of a consolidation of all this, of in maybe arbitration, if everybody has an arbitration clause, it can easily be consolidated when the clause is drafted to allow consolidation. So that's another point. And then you please look at the laws. Some laws may have changed, you know, before you pick anyone, look for laws where allows ease of enforceability of the decision at the end of the day. You know, that's the end game. You get a decision and the other party is not complying, you should be able to enforce it. So look at do your research on the current legal framework and the ease of enforcing this the decision from that particular agreement. Like negotiation, you have to start taking it back to court if the other person does not want to comply, you know. So you have, and if you have a project where you know that, okay, the time frame too is important, that this is a short project, that okay, it's like maybe 3 months renovation or something, and you want to put arbitration or litigation there, you know, the contract will finish or something, and then you're still, the matter is still in court, you know. And then what just crossed my mind now? Enforceability. Anyway, that basically covers it. What?
Thank you, Rudy. You've actually really covered the field, and I really like the way you broke this down. You know, one of the things you said, you mentioned how, you know, you look at a provision in a contract and it's a very simple building project and you're having 3 arbitrators and all that. I mean, it flashed my mind back to a client we had just a couple of years ago, who apparently was the weaker party, the contractor was a weaker party. And this is, it was an oil and gas, you know, contract, because we do have all these building projects and construction projects as well in oil and gas, and particularly oil and gas and power projects as well, and renewable projects, you know, as well. And I recall that, so the contractor was going to, you know, against the employer. And we look at the contracts and the arbitration clause, you know, it was arbitration that was provided, just arbitration. And there was the need for 3 arbitrators and this and that and all. And the contractor could not afford the cost of arbitration. And unfortunately, we had to withdraw from that claim. And it was such a shame. And it was something that I had to actually discuss with my team going forward, that we need to be extra careful. You need to look at the scope of the project, the value of the project before you start writing very high sounding
Elaborate.
language, and this is where we really need to speak to lawyers as well, because sometimes lawyers, in the bid to write, to put clauses together and have a very nice verbose language, you miss the commerciality and the interest of your client. So it's really very important. And one of the things I have heard is that there are fast track arbitration clauses that smaller projects can adopt. And what that usually does is it's usually for smaller claims, and it would involve shorter schedules, a single arbitrator, and I think where you have multi-layer subcontractors, small construction contractors and all that, who are not really, that have limited scope in a larger project. These are some of the things that levels of clauses and provisions that should be allowed in there. I think it takes a little bit of expertise on the part of the lawyers, and of course the experience of the project promoters as well.
And you should also, you don't have that much, you can also ask your that was what has kept my mind. Seek for advice, talk to somebody, a colleague that does that type of thing. Oh, I have this, so how do we do it? Basically, in construction contracts, there are standard forms of contracts, that you just use, but you can amend them to suit your own stuff. You pick out some things and you want, and you delete the other ones. But be careful when you are amending, because there are so many documents. Make sure you amend everything, that it ties down, it all comes together at the end of the day, because any ambiguity in the contract will be interpreted against you, the contract preferential rule, so you have to be mindful of that too. So I totally agree with what you have said so far.
Yeah, precisely. Thank you very much. So I think this is what I call copy and paste, but paste special. We lawyers have to learn to do that a lot, because a lot of clauses that we have in some of our agreements, they're just copy and paste, and we don't take time to look at the peculiarity of and then some contractors feel that this popular saying, "What lawyer did do safe?" So sometimes I think they don't need an experienced lawyer. Any lawyer would do, or anybody would do, and then sometime down the line they get into trouble. Now I know there are a lot of construction contracts, and the dispute resolution clauses in construction contracts. Sometimes you have mentioned that as well in passing. They have this multi-tiered or multi-layered system of decision making, where you might have an initial decision maker for a quick initial resolution, and where the parties are not satisfied, then you now have the layer of mediation, probably adjudication, like you mentioned, or experts determination, and arbitration or litigation, or any other binding dispute resolution clause that might have been incorporated into the contract. Can you please comment on the use of this multi-tiered dispute resolution clauses in construction contracts? Is it all contracts that require it, and what was there to look out for before determining what kind of multi-tiered system to use?
Okay, not all, is a matter of choice. Not all contracts use it. Multi-tiered dispute resolution clauses is just packing up the dispute resolution plus dispute resolution methods that I mentioned. You just pick like putting the steps on a ladder. First of all, we start with negotiation. If we don't agree or the negotiation does not settle the matter, we go to mediation. That's when we bring in a third party. If it does not settle the matter, we go to expert determination or dispute resolution, dispute adjudication board. If that does not settle it, will now go finally to what's it called now, arbitration, which will settle full and final settlement is arbitration. So those are stats. So you just see people going from step to step. It's useful because it small cases, easy disputes can just be settled by mediation. You don't have to go through everything, but some of them have to go through everything. So it kind of sieves the cases that get to the the arbitration. So it's just really, really complex and serious matters that finally get to arbitration. But it has the advantage of is, quickly, if we settle it in mediation, then the matter is over. We have saved money. We don't have to pay lawyer, and all that. You've saved money. The project is going on. Adjudication too allows the project to keep on going. Well, even if we are in dispute, the matter is still going on. So, but it has a disadvantage of delay. The parties can delay the matter using that one, saying that and we have to do negotiation first. Now, I mean, the party that maybe does not want to pay the money, you will just say, okay, we have to negotiate first. You will not agree till the last day. Maybe you put 30 days, the whole 30 days, you will not agree. You now say, we have to move to mediation, to go through all that. So it could act as people can be strategic, using it to delay the matter. So when you're using multi-tiered dispute resolution clauses, when you're drafting it, make sure to be clear to put in a trigger event or action. For instance, you'll be like, I have a standard form of a multi-tiered dispute resolution clause. Let me pull that up. You should have a trigger event, like the contractor should send in a notice of that he wants to refer the matter to negotiation. For instance, you should put a timeline so that there is no delay. You can say if the dispute is not settled within 20 days, 30 days, then it has to move on to the next thing. So putting all those timelines would prevent what's it called, delay, parties using it to delay. And you can also make it kind of like a condition precedent. That's another issue that can come up, that okay, non-compliance, some parties may say that I can't be waiting to be jumping all these loops all the time, going from mediation to negotiation before I collect my money, or you have to go step by step. Oh yeah, I'm just going to go straight to arbitration. That's a breach of contract, and because you have already agreed to go through those steps.
Sorry.
So yeah, so you jumping, that's a breach of contract, and it will rob the arbitral tribunal of its jurisdiction, because we know, like, there's this legal principle that I think Nkem Dilima Madukolo, that condition precedents to the exercise of the jurisdiction must be met. You have to comply with all conditions precedents, before you go to arbitration, the final one. So that's you could put it as a condition precedent too, like, okay, compliance with all those steps, you must have gone to mediation, dispute board, adjudication before you come to arbitration. So the International Bar Association, IBA, has a guidance notes on drafting international arbitration clauses. In that guidance notes, there is a standard form of a standard multi-tier clause. If I can quickly read it to you so that you can just have a picture. Yeah, so it says the parties shall endeavor to resolve amicably by negotiation all disputes arising out of or in connection with this agreement, including any question regarding its existence, validity, or termination. Any such dispute which remains unresolved 30 days after either party requests in writing, that's a trigger effect, that's the writing, request in writing negotiation under this clause, or within such other period as the parties may agree in writing, shall be finally settled under the arbitration rules of, let me say, the ICC or the LCI, the Lagos Court, the LCI, or any other arbitration rules they choose, by one or three arbitrators appointed in accordance with the said rules. The place of arbitration shall be, you stated, the city, the country, the language shall be English, so it is the IBA, this is IBA guidelines for drafting international arbitration clauses 2010. So if you Google that, you will get the guidance. The guidelines is about 50 pages, a 50-page document. You can use it not just for only construction stuff, you can use it. So the FIDIC uses a multi-tiered system, so it starts like that. They move from engineers' determination to the dispute adjudication or just dispute avoidance adjudication. And then you now have finally arbitration under the ICC rules. So FIDIC uses a multi-tiered system. So you could adopt that, or you can just say any issue that comes, we are just going to arbitration, and whatever they say is binding on us, or to adjudication, and it is binding on us. So yes, that is it.
Thank you very much, and thank you for providing that great resource, Ewuni. So, some of the things I hear about, using the tiered system of dispute resolution is to what extent can you actually include, the steps to be taken in the arbitration in the dispute resolution clause? Is it better to be as explicit as possible? I'll read some of the things that I've read about, that lawyers say, industry experts say that you should. So for instance, I'll use negotiation as my first example. So they recommend that right there in your dispute resolution clause, if you're using negotiation as one of the, the tiered, dispute resolution process, you should mention the negotiation period before initiation of mediation or arbitration, states the requirement to respond to notice to dispute, and within what period of time you're supposed to respond. If a party refuses to negotiate, whether the other party can immediately resort to arbitration or any other dispute resolution, mechanism that's provided in the contract, and what the time frame is. Participation by representatives having authority to make decisions, subject to possibly internal approvals. Participation by persons having knowledge of the underlying project and the source of the dispute. Extension of time limits, if to be agreed between parties. So if mediation is supposed to take negotiation is supposed to take place within a period of 10 days, if you want to extend, how many days is the maximum you can extend afterwards based on agreement of parties, the confidentiality provisions of courts, settlement negotiations, which are usually handled without prejudice, should that be stated clearly in the contract, the prohibition of raising the amount or the substance of the offers and responses. It goes on and on. Negotiations in the arbitration to allow negotiation by meeting in person or by other means such as telephone or video conference. So there are school of thoughts that think that because there's a possibility, like you mentioned earlier, for, should I use the word sharp practice, where either their legal representatives or the parties themselves can tend to use this mechanism to delay, especially when they know that they're in the wrong. So there is a school of thought that thinks that every single aspect, every step of each multi-tier system should be clearly stated. What's your own idea? How far, how large or wide can the scope of the dispute resolution clause be, or is it better to keep it short in righteousness, like they say? There are issues around confidentiality, proprietary knowledge, information, all in a negotiation dispute resolution clause.
Just one round of this. I think that would be too much information to be included in a dispute resolution clause. It's okay to like I said, and like the IBA suggests, put the triggering event, like that's giving a notice. Some things can be included, some key things can be included, and that's fine. The rest we can sort it out as we go along the way, subsequent agreement between parties. So you keep putting the triggering event, putting the what's it called now, the timeline is important, that within 2 so days, it's concluded. How you go about it, whether you get involved or not, if you put a timeline to it, it's that okay, by within 5 days or two months, we should have be done by this. It's okay. So I think that would be too verbose. It would be too unwieldy to put all that in it, just one wrong, when you go to negotiation, you can do that. And if a party does not want to negotiate, just mark time between left, right, there till your 30 days or whatever days you said you had agreed, which is and then we'll now move to the next step, and all that. So that way you fulfilled all the righteousness there.
Okay, thank you very much for that clarification. I would like to dwell a bit on mediation for just a moment. We know that, as lawyers, it was the old-fashioned system was, okay, even if you're going to put a clause on negotiation, it's just informal, between parties, maybe the executives of each party, and then from there you go straight to arbitration or litigation, as the case may be. But we're seeing more and more of structured and formal negotiation taking place now. And I understand that Nigeria recently, actually on 27th of November 2023, became the 13th state to ratify the Singapore Convention on Mediation, which incidentally will come into force in Nigeria this month, May 27th of this year, 2024. And for those who are not aware, the Singapore Convention is the United Nations Convention on International Settlement of agreements resulting from mediation. And the idea behind it is to try to look for an international commercial way of also settling disputes outside of arbitration. And so my thoughts are: did you think this convention is relevant in the construction space in Nigeria? And regardless of the type of project and the size of the project.
Yes, it's relevant, and it's really welcome because of the enforceability of the ease of enforceability of settlement agreements. Earlier, before the convention, you have to go to court because the settlement agreement is just a mere contract. If the other person does not comply with it, you cannot enforce it as like a judgment of the court, like happens in arbitration. But what this what's his name now, Singapore Convention has done is like it makes, I think, section 84 or 81 or 84 of the new AMA, the Arbitration and Mediation Act that was passed last year, 2023, makes a settlement agreement enforceable as in court. You take it to court and register it and enforce it like that, like an arbitral award. So it's a welcome development, and to bring more people, to make more people, both for domestic contracts and international contracts, domestic mediation, international mediation. Just when you get your agreement, to go and enforce it in court like that. So yeah, that's my opinion. It's going to encourage more people to use mediation. And more contractors to use mediation. And it's really good since mediation is fast. It preserves one thing I've not really harped on in this so far, preserves the relationship of the people, of the parties. We are talking as friends, as business men. We want to do more projects tomorrow. If I want to build another house, I want to call you to build it. I want you to call me too. They have this relationship should be preserved. So mediation allows it more than any adversarial method like what's it called now, arbitration or litigation. So those are my thoughts in regards to that, as regards that point.
Thank you, Uni. I think the thing is to sort of encourage lawyers more and more to use this, because it's definitely easier. Did you see this taking business on a lighter note, taking business from our arbitrators?
Arbitrators. No, I don't see that, because some people have I know go grease spirits,
but if isn't it possible that once it's tested and once it's tried and tested and it seems to be working, isn't it possible that we can begin to see contracts that don't even refer to arbitration as well, and make mediation the final bus stop, as you would say, to their dispute resolution?
It's possible, actually. Yeah, it's possible. Who knows? Things are happening. These are business people. The way the risk involved. I mean, if I can have you as my friend and I can negotiate that, okay, I'm going to give you this one, I'm going to allow you this one, but my next, mediation, you can come to terms, say, okay, I'll allow you, I'll collect the half price for this one, oh, but your next project, you give it to me, oh, and, you agree like that, it's flexible, and there's nothing you cannot agree to. Even if the contract is saying you're supposed to pay me within 30 days, you didn't pay me within 30 days, oh yeah, you pay me the money you were owing me plus interest. But this guy, people can come to mediation and agree that, okay, he did not pay me, but I'll agree that he will pay me only the money, forget about the interest, but you will give me another project. The next project that you are planning for, you will give me. Or the supplier said, I supplied you sand since you did not pay me. Oh yeah, for your next project is me that, oh yeah, give me contract to supply gravel. Something like that. People can come up with creative packages, and lawyers are there. We will not become redundant. We will be the one to say, okay, as you agree, know that you have so and so right, so you can also use that one to negotiate that. Because of this one, I will not go to court. I will not go to arbitration. Oh yeah, do something for me and I will not take you to court. That type of thing. So we would always be relevant, no matter the scenario, I think. And we have to keep ourselves relevant. We have to make them know that you need us, by
absolutely.
by making sense when we speak, so that's my
Very
opinion.
true. Very true. Thank you, Ibumi. I think I would like us to dwell a bit on the elements of a well-crafted dispute resolution clause. Before I go there, I think I want to use arbitration now. We've talked a bit about negotiation and mediation, and I would like to move to arbitration and then lead into this terrain. So, I mean, I do know that. So we want to dwell on the elements of a well-crafted or well-drafted dispute resolution clause. Now, if we use arbitration as an example, we know that aside from the language of the clause itself, we want to look at other elements that makes that dispute resolution clause enforceable. So we're looking at things like arbitration conventions and investment treaties. We're looking at the how enforceable that the forum of the arbitration as well is quite important, so that you are trying to do everything to ensure that there's an effective and enforceable arbitral dispute at the end of the day. And so these are some of the, so you're looking at things like arbitral rules, arbitral appointments, seat of arbitration, choice of law, language, and all that. That's for arbitration. And one of the things we see is that if your arbitration clause is poorly drafted and you get stuck in a situation where at the end of the day, the forum, because of the seat of arbitration you have chosen, the forum is not conducive and all that, you can get messed up. So, coming from this, what do you think are the elements of a well-crafted dispute resolution clause?
Okay, like you rightly said, it has to be clear. You use shall, don't use may. You use clear, concise terms, mandatory terms. If you use may or ambiguous things, you can shoot it off. They should do your research on the nominating, or let me not say appointing authority. If parties refuse to agree, the appointing authority shall be Chartered Institute of Arbitrators, Nigerian branch, Abuja chapter. There was a clause, there was a case we had one time like that when I was still with Biojo and Company. They put president of Chartered Institute of Arbitrators, Nigerian branch or so. Meanwhile, the office is chairman or so. I don't even know. All those nitty-gritty. So they said there's no appointing this thing, and then the respondents did not agree. So the whole thing was not unenforceable. You need to keep in mind all those little things like that. Do your research. Who is going to appoint? Who is there? Who am I going to call? Is it called? What's the title of that office? Is it chairman or is president? And you should also state whether the decision at the end, whether it's arbitration, whether it's adjudication, whether it's mini trial, expert determination, will that decision be binding? Or will it be binding and is it final? put it inside that your dispute resolution clause, so put the number of, if it's arbitration, number of arbitrators, like Aderemi had earlier said, number of the seats of the arbitration, that's where will it be held, what country to be held in, taking note of the laws that are there. Are they favorable to arbitration or to the process you have picked? In Nigeria, there is no law governing adjudication and construction adjudication like you have in Ontario, and you have in Ontario, Canada, and you have it in Singapore, you have it in New Zealand, you have it in the UK, but you don't have it in Nigeria. So it's whatever decision you have there, it is contract, so it's just a contractual thing. So you put it there, and whether the decision has to be reasoned. Sometimes an award, you might put it whether you want the award, the arbitral award to be reasoned, or the determination of the adjudicator to be reasoned. That's for the person making the decision to write the reasons for that determination. Why did you decide this way? You can put that in, that it has to be a reasoned award. Put in what the consequences of failing to comply. What will happen if this person does not comply? Does it give the person, does it mean that he has waived his right, or he's automatically taken to have, deemed to have accepted? That's not too important, but that one is if you want to hold the person by the neck like this, so you put in the governing law you have chosen. But before you do that, make sure you find out what the law, how that law is. Is it conducive? I had already alluded to that. Is it conducive to what you're saying? And the process of appointing incorporates rules. You don't even have to talk too much. Just say the rules of the ICC or the Abuja multi-door courthouse, or the rules of so and so place will be, of so and so institution will govern this thing. So you have incorporated those rules into your arbitration clause. You don't have to write it word for word, and that makes it so easy and straightforward. Put in timelines, like I said earlier.
Can I interject there, Ewuni? So if you put if you indicate your, maybe the arbitral institution that you want to conduct your arbitration without specifying the rules, is that enough? Can the institution then, automatically use the rules of their institution?
If you put in the rules that you want them to use.
No, if you don't,
the body,
you just state the body. So say you want your arbitration to be governed by, to be conducted by the ICC.
Under the IBC, automatically their rules would apply. Yeah. If you don't say that, okay, they should use this or that rules. It's possible because what is party autonomy in arbitration now? A party can choose whatever they want to do. They can say, we will do it in ICC, but you will use UNCITRAL rules. You will use the rules of I don't know, LCIA. Parties are free to do that. Maybe they're going to ICC because they like their administrative style, how they make sure you follow everything, how they monitor and go through the stuff. But the rules that we use is not ICC rules, so it's so and so rules. But if you incorporate the rules of ICC now, everything has to be done with ICC. You can use ICC rules, even if it's not ICC that is governing, that is it's not an institutional stuff. You can use ICC rules. You can use it if it's ad hoc. Do you understand? If it is just two people, two parties picking out their own arbitrators or so. But you have to specify the rules you want to use. If not, like in Nigeria, under the AMA, that's the Arbitration and Mediation Act, if you don't specify the rules, it's the arbitration rules of the AMA, under the AMA that you would use, that would come into play, if you don't specify the rules. Yeah, so
thank you very much.
That's a nutshell. Yeah.
Yeah, I think still just one more thing that I would like you to clarify for some of our participants who may not really know. One of the confusion that we usually have with arbitration clauses is the distinction between the seat of the arbitration, that's the forum, and the governing law of the contract. We know one deals with the procedural law and enforcement challenges and all that, while one is the governing law that actually applies to the interpretation of the contract. Can you please just quickly, give us clarity on this?
Okay, so the seats of the seat of the arbitration is like the country. Let's use the country. The seat is the country, Nigeria or UK, and then that's where it is the laws in the UK for procedure. Like, okay, you're supposed to file within what can I say, procedure for the enforcement of it. When you finish, you go to court under their civil procedure rules. That's how you will enforce this matter. That's what the Arbitration Act says in Nigeria. That Arbitration Act and all that's what it says. That it follows. That's what you will use to enforce the agreements. And you won't need to enforce if the other party complies. Always keep that in mind, sharp. Or enforcement is if the other party does not comply. So the seats gives you the law that you will use to enforce the stuff, and how the courts can intervene in your matter. There are certain things that how the courts can come into play in that arbitration. That's it. Then for the substantive law of the proceedings, of the contracts now, which law would this arbitral panel use to interpret the rights and obligations of the parties under this your construction contract? Since we are talking construction contract, for instance, which one will it be? What does that law say about delay and damages, for instance? That is what for damages, let's use damages. What is the damages? What does that law provide for damages? So for breach of contract, for all those things. That's the substantive law that the tribunal will apply to the disputes before them. I hope.
Absolutely. Thank you so much, Ewuni. I think this has been a very, very interesting conversation. I think before we round off, I would like to have your last thoughts, last comments, if any. What would be your parting message to our participants?
Oh, okay. I just wanted to know that construction law is not something scary. It's simple, it's easy, it's basically commercial law, where you have engineers, architects inside, but it's something you can do, and just give it your best. When you have a client, do your research. When you're drafting the contract, do your research, and that will ensure that they always come back to you. And if you don't understand anything, you can reach out to your colleagues, and get something done. And I just want to wish all of us the best as we practice, and to know that construction law is just commercial. It's an aspect of commercial law. It's just contract law, just with technical terms and words that are there. So it's easy and straightforward. People always say how they are scared, how it's scary and blah, blah. But it's not. If you just remove that construction, it's just law of contracts, law of agency, employment law. That's just what it is. Yes, thank you so much.
Thank you very much.
Opportunity.
Yeah, so we'll go to questions quickly. We don't have many, which is why I sort of allowed you to get into the conversation. Yeah. So there's Samuel Olisakwe says, where the parties are resident in Nigeria, the contract took place in Nigeria, the contract is to be performed in Nigeria. Can parties validly make a clause specifying that disputes arising from such contracts will be resolved in another jurisdiction? Let's say Canada or Singapore. Okay,
Yes, they can. That's party autonomy. For instance, in arbitration, that's another thing with ADR that is not court and litigation. It's just party autonomy. Parties can choose whatever they want to do, say whatever they want to do. They'll say the matter will be held in Singapore under French law. In that Singapore, we are going to use French law and they will speak Swahili. They can say any party can just mix whatever they want to do. That's the beauty of ADR, flexibility, So, and before you pick anything to like that, like I said, the cost of all those things, when you're picking anything, you consider it for your client's sake, look at your clients. Can they afford all those things? Do they themselves understand the language you're going to pick, And you should also think there's civil for international stuff, there's civil law, and then there's common law, which are different families of law.
Precisely.
And how the operate is different.
Yeah, so very important.
Yes, party can choose whatever they want to, wherever they want.
So we have Sorry to cut you short there.
It's
Thank you,
true.
Ewini. So we have
So,
a couple of hands that are raised. Samuel Lisakwe, I've read your question. I think I'll just take one more raised hand. I have to. It's increasing by the moment. Khadija Lagbari, quite a number of raised hands. Please go ahead with your comment. I think I will just be taking that one raised hand. So I would have preferred your comments or questions to be typed, you know. So Khadija, are you there? Whilst we wait for Khadija, one of the comments that I see repeated here is about the slides and the ability to have access to the to this session. And yes, I do know that the sessions would the link to the sessions are usually provided later on, so you can be rest assured about that. Now, when one of the things that I know our participants would like, in
just say
fact, I
that
see
there are no
participants
slides
asking.
actually. There are no slides. I didn't prepare slides. This is me talking from notes, and I just wrote down and stuff.
No, that's fine. So what I mean is the session itself is the link to the session is usually provided. So that should take care of that, so that we have participants and we have you know, members who can listen in online, you know, to the video later. So yes. One of the questions I see here that I was going to ask you anyway is, how can we get to buy your book? Where can we get to buy your book?
Oh, okay. So my book is available in Lagos and Abuja. In Lagos, it's available at Biojo and Company. It's in VI. If you can kindly Google their address, you'll get the addresses there. And then in Abuja, also Biojo and Company. You
can also type this, even if you can, in the chat.
Okay,
so
yes. Okay, you just send me an
yes.
email to info@I'll just type in my email address. So
exactly, that way people can get across to you as well to pick up their copies. There's this question. I think this will be the last question I will ask because time is up already. Some of the questions just came in now, you know, last minute. One just came in at 3. I would not take that. I will take the one before that. So it says, when the clause does not qualify as a court and every clause, does parties have rights to exercise their right to litigation?
Yes, your right to litigation is actually always preserved. You cannot oust the jurisdiction of the court. Last card, like we say in Nigeria.
The last hope of the common man.
Last. Court is there for you, you know. So if you come, they will stay. If you go in, they will stay proceedings for you. You go back to arbitration, you come back and say, we did not finish there, so and so happened. No, court will still hear you. So yes, your right to litigation is preserved. It's always there. Don't worry, you know. So yeah.
Okay, thank you very much, Ewuni, and our participants. This is a good place to wrap up this enlightening conversation. And for the vote of thanks, I would like to invite my chair, the learned SEN, Andrew Odum. Andrew, are you there?
Yes.
Thank you, Andrew. Please, the floor is yours.
I want to thank you so much. Our great moderator, Aderemi. And wow, Wuni, this is wonderful, wonderful session. Everyone across the country, across the globe, all the participants who have been thrilled, who have been educated. It's been exciting. I also congratulate the participants. Thank you so much, SBL, for giving us this platform. And participants who have more questions to ask, I know you also want to learn more. Come and join us in the committee. Join us.
Absolutely.
This is the SBL Committee on Construction Project and Infrastructure. And we have a lot to do together, a lot to learn, a lot to teach, and also to make money from, which is very important, and develop our country ourselves. Thank you so much. Thank you, everyone. Thank you.
Thank you very much, Andrew. That's coming from our chairman, Construction Infrastructure Committee. And guys, like he has said, we look forward to having you on board. And enjoy the rest of your day. Bye-bye.
Thank you, everyone. Bye-bye.
Bye, Uni. Thank you.